Oh, hello. Welcome to my bar review show. Today we're talking about contracts. Contracts involves formation, discharge, third-party beneficiaries, assignment and delegation, statute of frauds, parole evidence, conditions and performance, and finally, breach and remedies. I kind of group discharge, third-party beneficiaries, and assignment and delegation into one section. And I also do the same with statute of frauds and parole evidence. Let's see here. All right, so we have formation, discharge, third-party beneficiaries, assignment and delegation. These are all together. Statute of frauds and parole evidence. These are together. We have conditions and performance and breach and remedies. Let's take a nice breath because we're about to get into it. Let's take a nice break. You can pause the video here and come back when you like. All right, formation. It involves contracts formation and contract formation defenses, offer and offer termination, acceptance and additional or different terms, consideration and promises binding without consideration, enforceability and enforcement defenses, implied in fact and quasi-contracts, and finally, good sale contracts warranties. Contract formation. Binding contract requires manifestation of mutual assent, consideration, and lack of valid defenses. Contract formation defenses are no minds meeting due to mistake, misunderstanding, misrep, undue influence, duress, and capacity lack. We'll say it again. Binding contract requires manifestation of mutual assent, consideration, and lack of valid defenses. And again, binding contract requires manifestation of mutual assent, consideration, and lack of valid defenses. All right, we're going from formation to formation defenses. Formation defenses. No minds meeting due to mistake, misunderstanding, misrep, undue influence, duress, and capacity lack. No minds meeting due to mistake. Mutual mistake. Both parties are mistaken as to an essential element. Contract is generally voidable by party adversely affected if mistake existed when contract was formed. Mistake relates to basic assumption of the contract. Mistake has material impact on transaction, and adversely affected party didn't assume mistake's risk. Neither party can avoid contract if reformation is available to cure mistake. Unilateral mistake. One party is mistaken as to essential element of contract, but either party can enforce contract on its terms. Mistaken party can void contract if he did not bear mistake's risk, and either mistake would make contract's enforcement unconscionable, or non-mistaken party caused mistake, had duty to disclose, failed to disclose mistake, or knew or should have known other party was mistaken. Must be absence of serious prejudice to other party to rescind the contract. Reformation, mutual mistake. Court can reform writing except to extent third parties who relied on contract's rights would be unfairly affected. No minds meeting due to misunderstanding. Both parties believe they are agreeing to same material terms, but they in fact agree to different terms. Neither party knows or has reason to know. No contract if material term is involved. One party knows or has reason to know. Contract is formed based on material terms meaning as understood by the unknowing party. Both parties know terms are ambiguous at contract's formation time. No contract unless both parties intended same meaning. Waiver. One party can choose to enforce contract according to other parties' understanding. Subjective determination of misunderstanding. Each party's knowledge or reason to know of misunderstanding governs, not what a reasonable person would know. No minds meeting due to misrep. Untrue assertion of fact, present event, or past circumstance. Fraudulent misrep. Requires proof misrep is fraudulent. Knowing or reckless false fact assertion with intent to mislead. Misrep induced assent to contract in justifiable reliance on misrep by adversely affected party. Non-disclosure. Conduct to conceal fact or known facts non-disclosure is tantamount to assertion fact does not exist. Effect. Fraud in the factum, execution. Fraudulent misrep prevents party from knowing transaction's character or essential term. So, no contract is formed, and apparent contract is void unless reasonable diligence would have revealed contract's true terms. Fraud and inducement. Fraudulent misrep is used to induce another to enter the contract. Contract is voidable by adversely affected party if adversely affected party justifiably relied on misrep. Non-fraudulent misrep, innocent or negligent, renders contract voidable by adversely affected party who justifiably relied on material misrep and was induced to assent to contract because of misrep. Effect of party's fault. Party's fault in not knowing or discovering facts before entering contract does not prevent party's reliance on misrep from being justified, unless party's reliance on misrep constitutes failure to act in good faith. Cure of misrep. Contract is not voidable if facts cured before a deceived party has avoided contract. Avoidance or reformation for misrep. When contract's contents or legal effect is misrep, deceived party can avoid contract or reform contract to express what was represented. No minds meeting due to undue influence. Unfair persuasion of party to assent to contract. Unfair persuasion. Relationship between dominant and dependent party due to expertise, experience, or diminished mental capacity. Persuasion of one party seriously impairs other parties' free and competent judgment. Confidential relationship. Dominant party has burden of proving contract was fair. May be held to a higher disclosure standard. Third party undue influence. Victim may void contract unless non-victim contract party gave value or materially relied on contract in good faith and without knowledge of undue influence. Damages. Restitution is available. No minds meeting due to duress. Improper threat that deprives party of meaningful choice. Improper threat, it means a criminal or civil action threat made in bad faith, or threats to breach contract in violation of good faith and fair dealing. Deprivation of meaningful choice. Person has no reasonable alternative such that threat induced his assent. Effect on contract. Contract is void when duress is through physical compulsion and voidable in other instances. No minds meeting due to capacity lack. Infancy, under 18. Voidable by infant, but not by adult, except for necessary's reasonable value. Mental illness. Contract is void for one adjudicated mentally incompetent, but only voidable if there has been no adjudication. Guardianship. Contract is void for individuals under guardianship, except for necessary's reasonable value. Intox. Contract is voidable by intox party if intox party is unable to understand contract's nature or consequences, and other party knew of intox. Medium break. All right, we're moving on to offer and offer termination. Offer. Objective manifestation of offeror's willingness to enter agreement that creates acceptance power in the offeree. Offer involves intent, knowledge, terms, language, and invitation to deal. Intent. Statement is offer only if person to whom offer is communicated could reasonably interpret offer as offer. Expresses person's present intent to be legally bound by contract. Knowledge. Offeree must know of offer to have power to accept. Terms. Must be certain and definite, or contract fails for indefiniteness. Under common law, essential terms must be covered in contract. Essential terms are parties, subject matter, price, and quantity. If parties intended to create contract, court may supply missing terms. Under UCC, the only essential term is quantity, also parties and subject matter per themis. Exception. Requirements or output contracts. There, the UCC implies good faith. UCC fills the gap if other terms are missing. Other terms could be price, payment, delivery time, delivery place. Contract is formed if both parties intend the contract and reasonably certain basis exists for giving remedy. Language. Offer must contain words of promise, undertaking, or commitment, and be targeted to number of people who could actually accept. If return promise is requested, it's a bilateral contract. If an act is requested, it's a unilateral contract. Invitation to deal. Advertisements are only invitations to receive offers, but may qualify as offer if sufficiently specific and limit. Advertisements may qualify as an offer if they're specifically specific and limit who can accept, or if associated with a stated reward. All right, we're going from offer to offer termination. Offer termination involves time lapse, offeror's death or mental incapacity, destruction or illegality, revocation, revocation's limits, general offer's revocation, and finally, offeree's rejection. Time lapse, specified termination date or reasonable time period. Offeror's death or mental incapacity. General rule, offer terminates, even if offeree does not learn of offeror's death until after offeree has sent what he believes is acceptable. Exception. Offers for option contracts do not terminate because consideration was paid to keep the offer open. Destruction or illegality. Offer is terminated. Revocation. Offer can be revoked any time prior to acceptance. We'll say that again. Offer can be revoked any time prior to acceptance, even if the offer states offer will be open for a specific time amount. Revocation is not effective until communicated. Revocation sent by mail, not effective until received. Revocation's limits. Option contract. Offeree must generally give consideration for option to be enforceable. UCC Firm Offer Rule. An offer is irrevocable if offeror is merchant and assurances are made. Then offer will remain open. Offer is irrevocable if offeror is merchant and assurances are made. Then offer will remain open. No consideration is needed to keep offer open. Promissory estoppel. If offeree reasonably and detrimentally relies on offer, offer may become irrevocable. Partial performance. For all contracts, offeree must have knowledge of offer when performance begins. A unilateral contract, offeror cannot revoke once offeree has begun performance. Bilateral contract. Performance is beginning as promised to render complete performance. General offers revocation. Revocable only by notice, given at least same publicity level as offer. Effective even if potential offeree acts in reliance on offer. Offeree's rejection. Offeree clearly conveys to offeror he no longer intends to accept offer. Rejection is usually effective upon receipt. Counteroffer acts as original offer's rejection and creates a new offer. Break. All right, we're moving on to acceptance and additional or different terms. Offeree's objective manifestation to be bound by offer's terms. We have bilateral versus unilateral, acceptance means, mailbox rule, and notice. Additional and different terms involves common law mirror image rule and UCC no mirror image rule. Bilateral contract. Exchange of promises rendering both enforceable. Unilateral contract. One party's promise to do something in return for other parties' act. Starting to perform is not enough, but starting performance will make offer irrevocable for reasonable time period to complete performance. Offeree must be aware of offer before acting. Acceptance means. Offeree can accept in any reasonable means or manner, unless offeror specifies. Silence. Not acceptance unless offeree has reason to believe offer could be accepted by silence, or previous dealings make it reasonable to believe offeree must notify offeror if offeree does not intend to accept. Goods shipment. Buyer's request goods be shipped invites acceptance either by seller's promise to ship or by prompt shipment of the goods. Non-conforming goods shipped is both an acceptance and a breach unless seller seasonably notifies buyer goods are accommodation, a counteroffer. Buyer may then accept or reject non-conforming goods. Mailbox rule. Applies only to acceptance. Almost exclusively applies to bilateral contracts. Acceptance, effective when sent, not receipt, unless offer provides otherwise. Rejection following acceptance. Acceptance will control, even if offeror receives rejection first. But if offeror detrimentally relies on rejection, then offeree is stopped from enforcing the contract. Acceptance following rejection. Mailbox rule does not apply. First one received in offeror's possession or deposited in mailbox will prevail. Offeror need not actually read received communication. Revocation, effective upon receipt. Options and other irrevocable offers. Mailbox rule does not apply. Offeror must receive acceptance by certain date or before offer expires. Notice. Unilateral contract. Offeree is not required to give notice after completing performance unless offeror would not learn of performance with reasonable certainty and promptness, or offer requires notice. When notice is required but not provided, offeror's duty is discharged unless offeree exercises reasonable diligence to give notice, offeror learns of performance within reasonable time, or offer indicates notice of acceptance not required. Bilateral contract. Offeree must give notice of acceptance. Mailbox rule. Acceptance is valid when sent, though offeror has not received acceptance. UCC. If acceptance is made by beginning performance, then notice is required within reasonable time. Failure to give notice results in offer's lapse. All right, we're moving from acceptance to additional and different terms. Additional or different terms involves common law mirror image rule and UCC no mirror image rule. Common law mirror image rule. Acceptance must mirror offer's terms, so any change or addition to terms acts as rejection and new counteroffer. Conditional acceptance terminates the offer and acts as a new offer from original offeree. All right, UCC, no mirror image rule. Note there's no mirror image rule, but I have a bunch of slides with mirrors in them. Doesn't make sense. All right, acceptance containing additional or different terms generally is treated as acceptance. One or both parties are not merchants. Definite and seasonable expression of acceptance sent within reasonable time is usually original offer's acceptance, and new or different terms are treated as proposed contract additions that must be separately accepted by the offeror. Note, this is with one or both parties is not a merchant. All right, there's an exception. Acceptance is expressly conditioned on assent to new or different terms. That is treated as a counteroffer. Both parties are merchants. Battle of the forms. Additional terms automatically included in contract unless term materially alters original contract. Surprise or hardship would result. Offer expressly limits acceptance to offer's terms, or offeror objects to new terms within reasonable time after notice of new terms is received. If one of these exceptions is met, offer's original terms control. Different terms, the knockout rule. Different terms in offer or acceptance nullify each other, and court uses Article 2's gap-filling provisions to patch holes in contract. Acceptance based on conduct. If offer and purported acceptance differ too much to create a contract, but parties begin to perform anyway, then UCC allows contract to be recognized with the following terms. Any terms actually agreed on in parties' writings, and any supplementary terms filled in by UCC. Me, D, break. All right, consideration. Promises binding without consideration. Consideration involves bargain and exchange, and consideration's adequacy. Promises binding without consideration involves pay debt that is statute of limits barred, perform voidable duty, material benefit rule, and promissory estoppel. Bargain and exchange must be bargained for legal detriment to promisee. Legal detriment and bargain for exchange. To constitute sufficient consideration must be bargained for in exchange for promise. Promise must induce detriment, and detriment must induce promise. Consideration can be return promise to do something or performance of some act. Gift. Test to distinguish gift from valid consideration is whether offeree could reasonably believe offeror's intent was to induce action. If yes, then consideration exists and promise is enforceable. Promissory estoppel. If promisor or donor knows promise to make gift will induce promisee's substantial reliance, and failure to enforce gift would cause substantial injustice, then promise is enforceable. Consideration's adequacy involves subjective value, pre-existing duty rule, past consideration, modification, accord and satisfaction, illusory promise, voidable or unenforceable promises, requirements contracts and output contracts, and finally, legal claim settlement. Subjective value. Benefit to promisor need not have economic value. If promisor wants it, giving of it will constitute adequate consideration. Pre-existing duty rule, common law, doesn't qualify as consideration unless promisor gives something in addition to what is owed, or varies pre-existing duty in some way. Exception for third parties. Parties promise to third party to perform act party is contractually obligated to perform for another is sufficient consideration. Past consideration. The modern trend is toward enforcing past promises under a material benefit rule. Executory contract. Exchange of promises is adequate consideration. Modification. Common law. Must be consideration supported, and agreements to modify contract are enforceable if existing contracts rescission and entering new contract, unanticipated difficulties arise and modification is fair and equitable, or new obligations arise on both sides. UCC requires only good faith and no consideration is necessary. Accord and satisfaction. Accord. One party agrees to accept different performance from other party to satisfy other party's existing duty. Satisfaction. Accord agreement's performance will discharge both the original contract and the accord contract. Original contract is not discharged until satisfaction is complete. Unliquidated or disputed claim may be discharged by a negotiable instrument, a check with the note payment in full. Illusory promise is not legally binding because it is vague or promisor can choose whether or not to honor it. Voidable or unenforceable promises can still constitute consideration. Requirements contract. Buyer agrees to buy all she requires. Output contract. Seller agrees to sell all she manufactures. Consideration exists because promisor suffers legal detriment. Quantities may not be unreasonably disproportionate to estimates. Legal claim settlement. Promise not to assert or release of claim or defense is not consideration unless claim or defense is doubtful or party promising not to assert or release claim believed in good faith it is or was valid. We're moving from consideration itself to promises binding without consideration. Promises binding without consideration involve pay debt that is statute of limitations barred, perform avoidable duty, material benefit rule, and promissory estoppel. Pay debt that is statute of limits barred. New promise to pay debt after statute of limitations has run is enforceable without new consideration. Perform avoidable duty. New promise to perform avoidable duty is enforceable if new promise does not suffer from infirmity rendering it voidable. Material benefit rule. When a party performs an unrequested service for another party, the modern trend permits performing party to enforce promise or payment for material benefits received to extent necessary to prevent injustice, unless there's a donative intent. Promissory estoppel. Promise is binding if promisor should reasonably expect it to induce action on promisee's or third party's part. Promise is binding if promise does induce such action, and promise is binding if injustice only avoided by promise's enforcement. Break. All right, enforceability and enforcement defenses. Enforceability involves void contracts, voidable contracts, unenforceable contracts. Enforcement defenses involves illegality, unconscionability, public policy, and facts non-disclosure. Formation or enforcement defense may render a contract void, voidable, or unenforceable. Enforceability. Void contracts. Entire transaction is null, as if no contract existed. Voidable contracts operates as valid contract until or unless one party takes steps to avoid the contract. Unenforceable contracts. Valid contract that cannot be enforced if one party refuses to carry out its terms. All right, we're going from enforceability to enforcement defenses. Enforcement defenses involve illegality, unconscionability, public policy, and facts non-disclosure. Formation or enforcement defense may render a contract void, voidable, or unenforceable. Illegality. A contract is unenforceable if consideration or performance under the contract is illegal. Contract is void if contract contemplates illegal conduct. Duty to perform is discharged if contract becomes illegal after formation. If one party is justifiably ignorant of facts making contract illegal or lacks a legal purpose, he can recover, assuming other party's guilt. Illegality, ignorance. Oh, these are illegality exceptions now. So we have illegality exceptions and illegality ignorance. Promisee may recover if promisee is justifiably ignorant of facts making contract illegal and promisor had illegality knowledge. If both parties are excusably ignorant, promisee may have restitution claim. Illegal purpose lack. One who substantially performed may recover if contract does not involve illegal consideration or performance. Party is unaware of other party's illegal purpose. One who has substantially performed may recover if party knows of other party's illegal use, unless party furthered illegal use or use involves grave social harm. Divisible contracts. If contract can be easily be divided into legal or illegal parts. Divisible contracts. If contract can easily be divided into legal and illegal parts, then party may recover on the legal parts. Licensing violation. Depends on licensing's requirements purpose. If it's a regulatory purpose, one who fails to comply cannot enforce the contract. If it's a raising revenue purpose, party who fails to comply can enforce the contract. Restitution. Not in peri delicto. When parties are not equally at fault, less guilty party may recover under restitution. Withdrawal. Party who withdraws from a legal contract before improper purpose has been achieved may recover under restitution when party has not engaged in serious misconduct. All right, unconscionability. Contract is so unfair to one party, no reasonable person in party's position would agree to it. This is hidden or complex boilerplate language or adhesion contracts. Public policy. Contract may be enforceable if contract violates significant public policy. Facts non-disclosure. Facts non-disclosure equals misrep when person knows facts disclosure is necessary to prevent some previous assertion from being a misrep. Break. All right, implied in fact and quasi-contracts. Involve implied in fact contracts and quasi-contracts. Implied in fact contracts. Conduct, not words, indicates assent or agreement. Quasi-contracts. Plaintiff confers benefit on defendant, and plaintiff has reasonable compensation expectations, so court implies contract to prevent unjust enrichment. The requirements are a plaintiff conferred a measurable benefit on the defendant, plaintiff acted without gratuitous intent, and it's unfair to let defendant retain the benefit. Break. All right, goods, sales, contracts, warranties. We've got express warranty, implied warranty of merchantability, implied warranty of fitness for a particular purpose, and finally, disclaimer of implied warranties. Express warranty. Any promise, affirmation, description, or sample that is part of bargain's basis, unless it is merely seller's opinion. Disclaimers that unreasonably negate or limit express warranties are inoperative. Implied warranty of merchantability. Implied whenever seller is a merchant, seller dealing in goods of kind sold. Goods must be fit for their ordinary purpose. Implied warranty of fitness for a particular purpose. Implied whenever seller has reason to know from any source buyer has a particular use for the goods and the buyer is relying on the seller's skill. The warranty can be disclaimed by a conspicuous writing. Disclaimer of implied warranties. Implied warranty of merchantability disclaimer. Oral or written disclaimer using term merchantability. The writing must be conspicuous. Implied warranty of fitness for a particular purpose disclaimer. Disclaimer may use general language, but must be in writing and conspicuous. All implied warranties. Language makes plain there is no implied warranty. So for instance, sold as is. Buyer's inspection of the goods, excluded or modified by course of dealing, course of performance, or trade usage. All right, let's take a nice break. You can pause the video here and come back when you like. All right, we're back. We're talking about discharge, third-party beneficiaries, and assignment and delegation. Discharge, impracticability, purpose frustration, rescission, release, and destruction or damage to ID'd goods. Impracticability. A defense is available if performance becomes illegal after contract is made. Contract-specific subject matter is destroyed. Performing party to contract dies or becomes incapacitated, a personal services contract, or performance becomes impracticable. Elements. Unforeseen event has occurred. Event's non-occurrence was basic assumption on which contract was made, and party seeking discharge is not at fault. Timing. Usually arises after contract formation, but fact making contract performance impractical can exist when contract is made if party has no reason to know of fact. Assumption of risk. Impracticability defense is not available to party who assumes the risk of event happening. Assumption of risk. Impracticability of defense is not available to a party who assumes the risk of the event happening. Partial impracticability. Temporary impracticability only suspends the duty. It's discharged if performance is materially more burdensome after impracticability ends. If seller is able to deliver some goods, those goods must be apportioned among all buyers with whom seller has contracted. Buyer may refuse to accept and may cancel contract. Particular sources failure. If contract specifically identifies source and supply source fails, then performance is discharged even if other sources are available. All right, purpose frustration, 1 of 4. Applies when unexpected events arise that destroy one party's purpose in entering contract, even if contract's performance is not rendered impossible. 2 of 4. Frustrated party is entitled to rescind contract without paying damages. 3 of 4. Unexpected event need not be completely unforeseeable, but must be so severe it's not within assumed risks inherent under the contract. 4 of 4. Timing. Can arise at contract time if party has no reason to know fact exists. Rescission. Canceling contracts so as to restore parties to their position before the contract was made. Parties may seek to rescind for a variety of reasons, but rescission grounds must have existed at the time the contract was made. Rescission also possible by parties' mutual agreement. Right surrender under original contract is consideration for rescission. Third-party beneficiaries. Contract is not discharged by mutual rescission if third-party rights have already vested. Release. Writing that manifests intent to discharge another party from an existing duty. Common law. Release must be supported by consideration. UCC. Written waiver or renunciation signed or delivered by aggrieved party is enough. No consideration necessary. ID'd goods, destruction or damage. Destruction. Goods identified when contract made are destroyed by no fault of either party before loss risk passes to buyer. The contract is avoided. Both parties are discharged and neither party is in breach. Goods damaged but not destroyed. Contract is avoided, or buyer can choose to take goods at a reduced price without any other claim against seller. Loss risk. If loss risk has passed to the buyer, contract is not avoided and seller may demand buyer's performance. All right, moving on to third-party beneficiaries. This involves intended and incidental beneficiaries, vesting of beneficiaries' rights, and defenses. When two parties contract with understanding and intent, one party's performance is to benefit a third person. Intended and incidental beneficiaries. Third party can recover if third party is intended beneficiary. Intended beneficiaries. One to whom promisee wishes to satisfy obligation or otherwise benefit by promised performance. This intended beneficiary has a right to bring action on contract. Incidental beneficiary. One who benefits from contract though no contractual intent to benefit that person exists. No right to enforce the contract. Vesting of beneficiaries' rights. Intended beneficiaries' rights vest when beneficiary detrimentally relies on rights created, manifests assent to contract at one party's request, or files lawsuit to enforce contract. Defenses. Promisor can raise any defense against third party the promisor had against the original promisee. All right, assignment and delegation involves rights assignment, duties delegation, and contracts assignment. Rights assignment. Not allowed when rights assignment materially increases obligor's duty or risk, or materially reduces obligor's chance of obtaining performance. Need present intent to transfer right immediately. If assignment is for consideration, assignment is irrevocable. Gratuitous assignment, which has no consideration, automatically revoked on assigner's death, incapacity, or bankruptcy. Assignee takes all assigner's rights as contract stands at assignment time, but assignee takes subject to any defense that could be raised against assignor. Prohibition on assignment does not affect rights assignment, but bars duties delegation, unless circumstances indicate otherwise. Duties delegation. Generally allowed except when other contract party has substantial interest in specific individual's performance. Personal services contract involving special skill. When obligations are delegated, delegator is not released from liability, so delegator is still liable if delegate does not perform, unless a novation exists. So there's a note, mere consent to delegation does not create a novation. Delegate's delegation acceptance constitutes promise to perform delegated duties. Promise is enforceable if consideration or consideration substitute exists. Other party may treat delegation in good sale contracts as creating reasonable insecurity grounds. Other party may demand assurances from delegate. Permitted delegates conforming promises must be accepted. Prohibition on assignment does not affect rights assignment, but bars duties delegation, unless circumstances indicate otherwise. Contracts assignment. Assignments not limited to contractual rights, this contract assigned to, are generally treated as both rights assignment and duties delegation. Let's take a nice break. You can pause the video here and come back when you... All right, we're back. Now we're going to talk about statute of frauds and parole evidence. Statute of frauds involves writing required and contract types within statute of frauds and exceptions. Parole evidence involves integration and when parole evidence is inapplicable. Statute of frauds, writing required. Memo must be in writing, be signed by party to be charged, any authentication that IDs party, and contain deal's essential elements. Memo must be in writing, be signed by party to be charged, any authentication that IDs party, and contain deal's essential elements. Contract types within the statute of frauds. M. Sauer involves marriage, suretyship, 1 year, UCC, and real property contract. Marriage, any agreement in marriage's consideration. Suretyship, contract to answer for another's debt or duty. 1 year, contract that can't be performed within 1 year after contract is made. UCC, when goods sale contract is at least $500, memo must indicate contract has been made, ID the parties, contain quantity terms, and party to be charged signs. The exceptions, writing is not required under the UCC for specially manufactured goods, partial payments, receipt and acceptance, judicial admission, or failure to object to memo within 10 days of receipt when both parties are merchants. Real property contract applies to contracts providing for subsequent conveyance of property interest. Subsequent acts showing contract's existence may also make oral contracts for interest transfers enforceable. Real property contract applies to contracts providing for subsequent conveyance of property interest. Subsequent acts showing contract's existence may also make oral contracts for interest transfers enforceable. Exceptions, statute of frauds exceptions. We have promissory estoppel and judicial admissions. Promissory estoppel, judicial admissions. Break. All right, parole evidence involves integration and when parole evidence is inapplicable. In general, parole evidence prevents introduction of prior extrinsic evidence that contradicts written contract's terms. Integration. Parties intended writing to be their final agreement. Parole evidence rule applies. We'll talk total integration and parties' intent. Total integration. Complete expression of all terms of parties' agreement. Parties can't introduce extrinsic evidence of prior or contemporaneous understandings or negotiations. Partial. If writing sets forth only some terms, then parties are permitted to introduce supplementary extrinsic evidence of other terms that are consistent with the writing but not contradictory. Parties' intent determines if total, partial, or no integration exists. Common law, four corners rule, can only look to the writing itself for intent. Second restatement. If extrinsic agreement, term would naturally be omitted from writing, then term can be introduced as long as term isn't contradictory. UCC assumes written contract is only partial integration and allows almost any outside terms. When parole evidence is inapplicable, does not apply to communications occurring after written contract's execution and when parties are raising formation defense, raising enforcement defense, proving condition precedent to contract's existence, interpreting or clarifying contract ambiguity. Finally, UCC. Raising formation defense. Raising enforcement defense. Proving condition precedent to contract's existence. Interpreting or clarifying contract ambiguity. UCC. Supplementing even apparently unambiguous terms by trade usage or course of dealing evidence. Priority, highest to lowest, will start with express terms, then course of performance, then course of dealing, then trade usage. Let's take a nice break. You can pause the video here and come back when you like. Okay, we're back. Let's talk conditions and performance. Conditions and performance involves conditions, condition timing, condition satisfaction, contract duty performance, and condition suspension or excuse. Conditions. Future events that must take place before rights or obligations are created, destroyed, or enlarged. We'll talk about conditions failure, express conditions, and implied conditions. Conditions failure. Relieves party of obligation to perform. Express condition. Contract includes words like on condition that or provided that. Condition must be complied with fully unless excused. Substantial performance will not suffice. Enforceable even when failure to meet condition results in compensation denial. Implied condition. Conditions deemed contract part because agreement suggests parties truly intended condition, but fail to expressly include condition or because fairness requires conditions inclusion. Only substantial performance required to satisfy condition. UCC implies a cooperation duty when one party's performance depends on other parties' cooperation. Condition timing. We've got condition precedent, condition subsequent, and concurrent conditions. Condition precedent. Condition precedes obligation to perform. Condition subsequent. Condition excuses duty to perform after a particular event occurs. Concurrent conditions. Each party's duty to perform is conditioned on other parties' duty to perform. Each party must perform simultaneously. Condition satisfaction. Examined against objective reasonable person standard, unless aesthetic taste is involved, then a subjective standard. Party must use good faith when assessing satisfaction. Dissatisfaction must be honest, but may be unreasonable. All right, contract duty performance. We have performance order, substantial performance, UCC perfect tender, divisible or installment contracts, and finally implied good faith and fair dealing duty. Performance order. Unless language or circumstances indicate otherwise, performance is due when one party's performance requires a time period. That party must complete his performance before the other party is required to perform. When both parties' performance can be rendered at the same time, both parties must perform at the same time. One party's failure to perform excuses other parties' performance. Substantial performance. Express condition precedent. Parties generally held strictly to condition. Full compliance is required before other parties' performance is due. Implied or constructive condition precedent. Party who substantially complies with condition can trigger other parties' obligation to perform. Damages. Contract price minus any amount it will cost other party to obtain complete performance as promised. Even if no substantial performance, potential recovery is available through restitution. Failure to substantially perform is a material breach. Willful breach. More likely to be treated as a material breach. Substantial performance less likely to be found when breach is willful. UCC perfect tender. Seller must transfer ownership and tender goods conforming to warranty obligations. Buyer may inspect goods and on acceptance has obligation to pay for them. Perfect tender rule. Substantial performance is insufficient, except for installment contracts and when the parties agree. Transferring ownership. Automatic warranty of good title, rightful transfer, and goods free of security interest of which buyer is unaware. Actual knowledge of security interest nullifies warranty of title. Seller's obligation to tender goods. If the contract is silent on tender, then must be in accordance with contract provisions or with the UCC. Tender method. Seller's business place. Seller must place goods at buyer's disposition and give buyer notice if necessary. Shipment contract. FOB seller's business place. Seller must deliver goods to carrier and make contract for their shipment. When contract is silent, shipment contract presumed when contract requires a third-party carrier shipment. Destination contract, FOB buyer's business place. Seller must deliver goods to place specified in contract and tender them there by holding them at buyer's disposition. Buyer's obligations. Once conforming tender is made, buyer is generally obligated to accept and pay contract price. Rejection amounts to contract breach. Buyer's right to inspect before payment. Generally, right to inspect goods tendered, delivered, or ID'd on contract for sale, unless contract provides otherwise. Contract specifications left to one party. Otherwise valid contract is not invalid merely by omitting details to be specified by one party. Specification must be commercially reasonable and made in good faith. Divisible or installment contracts. Common law. Various performance units divisible into distinct parts. Recovery is limited to amount promised for contract segment performed. Damages are recoverable for other segments as breach. So you get money for what was performed and you get damages for the other segments. UCC. Goods delivered in multiple shipments, each to be separately accepted. Perfect tender rule does not apply. Right to reject is determined by a substantial conformity standard. Buyer can only reject if nonconformity substantially impairs value to buyer and cannot be cured. Buyer may cancel contract only if nonconforming tender substantially impairs entire contract's value. Implied good faith and fair dealing duty. Imposed on each party in any contract, common law or UCC. Good faith means honesty in fact and observance of reasonable commercial standards of fair dealing. All right, condition, suspension, or excuse. We have waiver, wrongful interference, election, estoppel, and forfeiture. Waiver. Party whose duty is subject to condition. Waiver. Party whose duty is subject to condition can waive non-material condition by words or conduct. Party may reinstate conditions material to party's primary purpose. Non-material condition may be reinstated if waiving party communicates waiver's retraction before condition is due, and other party has not suffered detrimental reliance. Wrongful interference. If party whose duty is condition subject wrongfully prevents or interferes with that condition's occurrence, then condition is excused, and interfering party has absolute duty to perform, per implied duty of good faith and fair dealing. Election. Party who chooses to continue with contract after a condition is broken effectively waives that condition. Estoppel. Once party waives condition, party can be estopped from using that condition as defense if other party reasonably relied on waiver. Forfeiture. Court may excuse non-material condition if non-occurrence would cause disproportionate forfeiture. Let's take a nice break. You can pause the video here and come back when you like. All right, we're back. Now let's talk about breach and remedies. Breach and remedies involves contract breach, anticipatory repudiation, remedies, restitution and reliance recoveries, specific performance, and finally UCC remedies. Contract breach. Once duty to perform exists, non-performance is breach unless duty is discharged, common law and UCC. Common law, minor breach. Breacher has substantially performed. Non-breacher is entitled to pursue remedies for non-material breach, damages, but must perform under contract. Material breach. Non-breacher doesn't receive bargain substantial benefit. Allows non-breacher to withhold any promised performance and pursue remedies for breach, including damages. UCC. In general, seller must strictly perform all obligations under contract or be in breach. Material breach is only applied to installment contracts or when parties say it in the contract. Anticipatory repudiation. We'll talk about it in terms of the common law, in terms of the UCC, and one's prospective inability to perform. Let's talk the common law. Promisor repudiates before performance's time is due. Repudiation must be clear and unequivocal, words or acts. Non-breacher's options. Treat repudiation as breach, or ignore repudiation and demand promisor's performance, but suspends any performance by promisee if it would increase promisor's damages. If performance date has not passed and the only performance left is payment, must wait for actual breach before filing suit. Repudiation's retraction. Can be retracted until promisee acts in reliance on repudiation, accepts repudiation, or commences contract breach action. Unilateral contracts. Anticipatory repudiation does not apply. All right, we're switching from common law and we're going to the UCC. Anticipatory repudiation under the UCC equals buyer or seller's unequivocal refusal to perform, exist, or when reasonable grounds for insecurity arise and other party fails to provide adequate assurances within reasonable time, not to exceed 30 days. Repudiation's retraction. It's permitted if the other party has not canceled the contract or materially changed position. We're switching from the UCC to prospective inability to perform. Parties' performance expectations may be diminished by event occurring after the contract was formed. UCC. Party can demand assurance if reasonable grounds for insecurity about other parties' ability to perform exist, and may suspend performance until provided. Demand must be made in writing. Failure to provide adequate assurances within the reasonable time, limited to 30 days, is treated as repudiation. Remedies. Remedies are a long one. They have expectation damages, consequential damages and foreseeability, incidental damages, liquidated damages and penalties, punitive damages, nominal damages, attorney's fees, and mitigating damages. Expectation damages involves, in general, partial performance, defective performance, economic waste, UCC warranty breaches damages. In general, intended to put non-breacher in the same position as if contract had been performed. Must be calculated with reasonable certainty. Expectation damages equal loss in value plus other loss, minus cost avoided minus loss avoided. If using this formula, plaintiff should not recover separately calculated consequential and incidental damages. Partial performance. Partially performing party recovers work performed plus expectation damages for work not yet performed. Defective performance. Construction contracts. Damages. Generally cost to correct defect. Goods sale. Damages are equal to the difference between goods value as warranted and actual value of tendered non-conforming goods. Real estate. Damages for failure to perform equal the difference between the contract price and market value. Damages for late delivery equal fair market rental value. Economic waste applies to construction contracts. Occurs when cost to fix or complete construction is clearly disproportional to any economic benefit or utility gained as a result. Court can award damages equal to diminution in property's market price. If breach is willful and only contract's completion will give non-breacher benefit of its bargain, court can award damages to fix or complete construction, even if it results in economic waste. UCC, warranty breaches damages. Difference between value of goods accepted and value goods would have had if goods had been as warranted. Often it's repair cost. All right, consequential damages and foreseeability. This involves direct damages, consequential damages, foreseeability, causation, reasonable certainty, limitation by agreement, and UCC. Direct damages. Defendant's wrongful acts necessary and usual result. Values loss. Consequential damages. Damages that result from breach, but arise out of special circumstance unique to contract parties. Must be reasonably foreseeable to breacher, caused by breach, and reasonably certain in value to be recovered. Foreseeability. Unforeseeable. Not recoverable unless breacher had some reason to know of unforeseeable consequential damages possibility. Damages are recoverable if damages are breach's natural and probable consequences, or if parties contemplated damages at contract formation, or if damages were otherwise foreseeable. Causation. Defendant's defense. Plaintiff's losses would have occurred regardless of defendant's breach. Reasonable certainty. Damages dollar amount must be proven with reasonable certainty. If lost profits are too speculative, courts may limit recovery to reliance damages, reasonable expenditures made in connection with contract. Limitation by agreement. Agreement to expressly exclude or limit consequential damages is generally enforceable. UCC. Only buyers can seek consequential damages under the UCC. A seller is permitted to seek consequential damages based on common law or other statutes. Limitation of consequential damages for personal injury in consumer goods case is prima facie unconscionable. Damages limited when loss is commercial is not prima facie unconscionable. All right, incidental damages. Compensation for commercially reasonable expenses incurred as a result of other parties' breach. If it's a seller's breach, if seller breaches, then buyer gets expenses from inspection, receipt, transport, care, and custody of goods rightfully rejected. Buyer gets cover expenses. Buyer gets any other reasonable expense incident to delay or other breach. Buyer's breach. Any expenses incurred in stopping delivery and transportation, care, and custody of goods after buyer's breach, in connection with goods' return or resale, or otherwise resulting from breach. Liquidated damages and penalties. Damages stipulated by contract parties as reasonable estimation of actual damages to be recovered in event of breach. Enforceable if parties intended to agree in advance to damages that might arise from breach. Stipulated amount was reasonable at contract time, bearing some relation to damages. Actual damages would be uncertain in amount and difficult to prove. Punitive damages. These are rarely available in contract actions, but may be available if conduct constituting breach is also recoverable under tort theory. Nominal damages. When no damages are alleged or proven. Attorney's fees. In contract, not recoverable absent express agreement or specific law. Mitigating damages. Contract party must avoid or mitigate damages to extent possible by taking steps that do not involve undue risk, expense, or inconvenience. Non-breacher is held to reasonable conduct standard in preventing loss. Services contract. Party is generally not required to accept any type of employment. Only employment of same type as party was contracted to perform. Failure to mitigate reduces damages that may be recovered by a non-breacher. And we're done with remedies. All right, restitution and reliance recoveries. Involves restitutionary damages and reliance damages. Restitutionary damages. Restores to party benefit conferred on other party. Measured by either reasonable value of defendant obtaining that benefit from another source, or increase in defendant's wealth from having received that benefit. If plaintiff has not substantially performed and is in breach, plaintiff is not permitted to recover. Non-breacher's recovery. Non-breacher may recover for any benefit conferred on breacher by way of part performance or reliance. Non-breacher may not recover restitution if he has fully performed and the only remaining performance by other party is payment of a definite money sum. Breacher's recovery. If defendant has benefited from plaintiff's performance, then plaintiff can recover benefit conferred less defendant's damages for breach. Plaintiff generally cannot recover if plaintiff's breach was willful, or if contract provides non-breacher may return value of breacher's performance as liquidated damages. Reliance damages. Non-breachers incurred reasonable out-of-pocket expenses. These are recoverable if non-breacher incurs expenses in reasonable reliance on promise other party would perform. Party cannot recover both reliance and expectation damages. Specific performance. All right, specific performance is a possible equitable remedy when damages are an inadequate remedy. We'll talk the factors considered, real property, UCC, and equitable defenses. Factors considered in determining whether damages are adequate. Mutuality of agreement. Difficulty of proving damages with reasonable certainty. Enforcement's practicality. Parties' wishes and understandings. Balance of equities. And finally, hardship to defendant. Real property. Specific performance is granted because real property is considered unique. UCC. Specific performance may be granted to buyer when goods are rare or unique. Equitable defenses. Latches. It's a prejudicial delay in bringing action. Or unclean hands. Non-breacher is guilty of some wrongdoing in transaction. The breacher may raise this. All right, UCC remedies. UCC remedies involves buyer's remedies, seller's remedies, loss risk, sales contract or warranty breaches, statute of limitations. UCC remedies, buyer's remedies. When seller fails to perform or makes non-conforming tender. We'll talk failure to tender goods and non-conforming tender. Failure to tender goods. Cancel contract if installment contract's breach goes to entire contract. Recovery of payments. On cancellation, buyer is entitled to recover payments made for tender. On rejection or revoked acceptance, buyer also gets security interest in goods in buyer's possession. Damages. Market price minus contract price, plus incidental and consequential damages. Cover. Buyer may purchase similar goods elsewhere and recover replacement price minus contract price. Specific performance for unique goods. Replevin. Buyer can obtain undelivered goods from seller if replevin. Buyer can obtain undelivered goods from seller if at least partial payment is made or buyer is unable to effect cover. Non-conforming tender. Buyer has right to accept or reject all or part of goods and right to inspect before making that decision. Rejection. Buyer can reject goods if buyer gives seller notice within reasonable time and before acceptance, and is then entitled to return any payments made or seek same remedies as if no tender was made. Acceptance. Buyer accepts goods by expressly stating acceptance, using the goods, or failing to reject the goods. To recover damages, buyer must give seller timely notice of breach. Damages are measured by difference between non-conforming goods value and conforming tender value, usually repair or replacement costs, plus consequential and incidental damages. Right to cure. Seller has right to cure defective tender if performance time under contract has not elapsed, or seller had reasonable grounds to believe buyer would accept despite nonconformity. All right, seller's remedies. We have the right to price, right to reclaim goods, stoppage of goods in transit, and finally buyer's wrongful rejection. Right to price. Seller may recover full price if buyer has accepted goods. Conforming goods are destroyed or lost after risk has shifted to the buyer. Seller cannot reasonably sell identified goods. Right to reclaim goods. From insolvent buyer if seller makes demand within 10 days after buyer receives the goods. Stoppage of goods in transit. Permitted if buyer breaches or is insolvent. Buyer's wrongful rejection. Seller can collect damages, resell goods, or recover price, and if seller is lost volume seller, lost profits. Seller can also collect incidental damages. Loss risk. Unidentified goods. If goods are damaged or destroyed and no breach exists, loss risk is on seller until seller satisfies delivery obligations. Then risk shifts to buyer. Shipment contract. Loss risk passes to buyer when seller gives carrier goods possession and makes proper contract for their shipment. Destination contract. Loss risk passes to buyer when seller, I don't know what that word is, when seller something goods at place specified in contract. Let's see. Destination contract. Loss risk passes to buyer when seller, I'll say, delivers goods at place specified in contract. All right, identified goods. Seller is excused if goods are totally destroyed through no fault of seller prior to loss risk shifting to buyer. Contract breaches effect. Seller's breach. If seller delivers non-conforming goods, loss risk remains on seller until buyer accepts or there is cure. Buyer's breach. If buyer breaches or repudiates after goods have been identified, but before loss risk shifts, then risk immediately shifts to buyer to extent of seller's insurance coverage lack. Sales contract or warranty breaches statute of limitations. 4 years after action cause accrues. Generally, action cause accrues when breach occurs, regardless of whether aggrieved party knows. Parties may reduce 4-year limitation period to not less than 1 year, but parties may not extend the limitation period. And we are done with contracts. Congratulations. We'll see you on the next video.